Imagine this, you walk into a courtroom, the accused says, I did not do it. The prosecution says, he did it. Now the $1,000,000 question is, how does the judge know who is telling the truth? The answer lies in evidence. Evidence is the backbone of justice. Without it, even the strongest arguments collapse, like a house of cards. In this video, I will explain the different types of evidence in law with powerful examples and famous case laws. Stay till the end to learn about the legendary 5 golden principle of circumstantial evidence that can make or break a case. Let's get started. So first of all, the question is, what is evidence? The word evidence comes from a Latin word evidence, meaning that which is clearly seen. In law, it simply means anything that helps the court decide the truth. It can be something you saw, heard, wrote, recorded, or physically produced. Now question is arise, why is evidence important? Basically, it proves or disproves facts. It supports your side or destroy the other side's claim, and most importantly, it brings the truth into the courtroom. Think of evidence like bricks in a building. No bricks is equal to no structure. Exactly like that, no evidence is equal to no case. Under section 2 clause 1 subclause E of the Bhartya Sakshya Adhiniyam says evidence includes oral evidence, that is statement made by the witnesses, and documentary evidence, any document or electronic record produced for inspection. These are called evidence that is given under Bhartya Sakshya Adhiniyam 2023 Act. So now let's understand what is oral evidence. This is the most common and human form of evidence when a person comes and speaks in court. That is called a oral evidence. Defined under section 54 and 55 of BSA, it must be direct and also based on personal knowledge, what the witness saw, heard, or sensed. For example, a witness says, I saw Ramesh hit Suresh with a bat. That's a oral evidence. In the case of Queen Empress versus Abdullah 1885 case, a mute victim used hand gestures to identify the attacker. The court said gestures count as valid oral evidence. Oral evidence includes signs and writing too. If we see oral evidence in our modern time, then it can be electronic, like a witness testifying by video call. This type of modern technology oral evidence also admissible. Now another type of evidence is indirect evidence. It's also called a hearsay evidence. Now this is where it gets tricky. Hearsay is equal to second-hand information. For example, X told me that Y saw Z doing it. This particular hearsay evidence not admissible in the court. General rules is this: the hearsay is not allowed, but there are some smart exceptions that's given under section 26 and 27. First one is the res gestae, that is spontaneous utterance during the event. And second one is the dying declaration and confession and admissions, statements in earlier proceedings. These are the exceptions to the hearsay evidence. The case of Pakala Narayan Swami versus Emperor 1939 case, in this case, a letter written before death was held admissible. Why? Because the victim had no hope of survival, making it a valid dying declaration. Another type of evidence is documentary evidence. This is where papers and digital records become a very powerful evidence. It defines section 2 clause 1 and subclause D of BSA. It includes all written, printed or electronic documents produced for the court's inspection. For example, contracts, letters, the emails, the CCTV footage, the WhatsApp chats and server logs. Why it's powerful? Because people lie but documents don't. Another type of evidence is primary evidence. This is the original, the king of documents. It's given under section 57. Primary evidence is equal to the original document itself. For example, original sale deed, handwritten letters, signed agreement, and original government issued certificate. These are the primary evidence. In the case of Muhammad Yaqub Ali versus State of Tripura 2004 case, in this, carbon copies prepared simultaneously were treated as primary evidence. Another type of evidence is secondary evidence. What if the original document is lost or destroyed? That's when the secondary evidence steps in. Section 58 and 60 explain the conditions. For example, certified copies, copies compared with original, and oral accounts by someone who saw the document. For example, if will was lost in a fire, the court may accept a certified copy or someone's statement who read it earlier. Another type of document is public and private document. Section 74 clause 1 says public documents maintained by government officials less likely to be fake. For example, FIRs, birth and death certificates, gazette notifications and court judgments. Section 74 clause 2 talks about private documents. It happened between private parties. Private documents between private parties need stronger authentication. For example, personal letters, business arguments and emails. Another type of evidence is real and physical evidence. This is the evidence you can touch, see or examine physically. For example, knife used in murder, then fingerprints, then blood-stained shirts and DNA samples. In the case of Marada Venkateshwar Rao versus Oleti Vanalakshmi 2008 case, in this case DNA test was crucial in proving maternity and accepted as real evidence. So, if a murder weapon is found with the blood and fingerprints, that's real evidence, a powerful visual and direct. Our another type of evidence is direct evidence. This is the cleanest type, no guessing, no assumptions. It directly proves a fact. For example, I saw him shoot the gun. No interference needed, just a fact. Now let's talk about the type that often makes or breaks high profile cases, circumstantial evidence. Circumstantial evidence does not directly prove guilt but points strongly towards it. For example, it shows the motive to kill, last seen together, blood-stained clothes and also accused fleeing from the scene. In the case of Sharad Birdi Chand Sarda versus State of Maharashtra 1984, in this, 5 golden rules for conviction on circumstantial evidence given. First one is the all circumstances must be proved. Second, must point only to guilt. Third, must be conclusive. Fourth, it must be rule out all other theories. And last one, it must be form a complete unbroken chain. In the case of Anant Chintaman Lagu versus State of Bombay 1960, in this, even when poison was not found in the body, circumstantial evidence proved the murder. In the Shalini Singh case, it was said that conviction upheld purely on circumstantial chain. So these were our different types of evidence. Every case is a puzzle and evidence is the pieces that complete the picture. As a lawyer or law student, your job is not just to argue but to prove, because at the end of the day, evidence wins cases, not emotions. If you found this video helpful, share it with your fellow learners. Tell me in the comments which type of evidence do you think is the strongest weapon in the court.